Good afternoon to those of you on the East Coast, and good morning to those of you on the West Coast. My name is Felix Shipkovich, and I am humbled to present my colleague Jessica Livingston in today's webinar, which is our annual webinar discussing the end of year legislative, regulatory, and litigation recap for the debt relief industry. We do this every year. We do it around this time, and we try to make it fun, interesting, and informative. For those of you who have attended our in-person workshop, it was a 2-day workshop about a month ago in Costa Mesa, California. We appreciate your support. We had a pretty decent turnout for a 2-day workshop, and we are very grateful to the CFPB sending their chief of staff for the markets division to be our keynote speaker. We have a lot of interesting topics to discuss today, and before we dive right into the subject matter and discuss 2022, I'll tell you this was a fun year. It was a very different year. It started off being extremely hectic for many attorneys in the space. If you're on the legal or compliance side, I'm sure you're pretty busy, probably about 6 to 7 months of the year. The number of CIDs, investigative demands, number of litigations that have been commenced in the first 6, 7 months of this year has been truly enormous. Things have generally subsided towards Q4 of this year. But what's peculiar, and we'll touch upon it towards the end of this webinar, is that the last week has been quite interesting, particularly coming from the CFPB side. So, without any further ado, I'd like you to meet my colleague, Jessica Livingston. Jessica.
Thank you, Felix. Hi, everyone. I'm Jessica Livingston. I'm the Florida partner of Shipkovich P. LLC, and I run the firm's Miami office. I represent clients in the debt settlement space, including debt settlement companies, front ends, and so-called third parties who are just wrapped up in various issues in the debt relief space. I handle cases that span from transactional contract reviews and drafting type of matters to managing litigation, sometimes in a general counsel capacity. I'm excited to be co-hosting today's webinar with you, Felix. This is a fun topic, the end of year roundup in the debt settlement space, and I'm glad to be here. Thank you.
Hey, thanks, Jessica. A little about myself is I founded this firm in 2011 after serving as a general counsel for CFTC regulated commodities brokerage. And since 2011, my firm represents companies, corporates throughout the world in the fintech space, crypto, money transmission, payments, and obviously in the debt relief space, we work with debt settlement companies, front ends or marketing companies, as I like to call them. Credit counseling agencies, we assist companies in investigation, litigation, licensing, and really provide a full service in other areas of law that assist our clients, do their day-to-day activities. Every spring, I teach at Hofstra Law School a course called The Policy and Business of Cryptocurrencies. And actually delighted to announce that I have a textbook that should be coming out in 2023 on the subject matter. And I have an offer on the table. And hopefully for those of you who are just really interested in the FTX and the crypto saga that's happening in the space, I hope you get a chance to read the textbook, which hopefully will be coming out in Q2 or Q3 of this year, depending on how quickly the publisher could get it out to the masses. Well, thank you. So let me turn it over to Jessica, and she'll kick off. Thanks.
Yep, thanks, Felix. So on today's agenda, we will have a quick overview of recent legislative and licensing updates in the debt relief space. We'll also go over a few TCPA or Telephone Consumer Protection Act and FCRA or Fair Credit Reporting Act litigation and regulatory updates. And throughout today's presentation, you can expect to hear Felix and I recap what regulators focused on in 2022 in the debt relief space, as well as some trends that we've seen in the FTC actions. And last but not least, we will let you all in on our predictions. What will 2023 bring? Felix has a forecast for both the regulators on the federal level as well as stateside. In this section, we're going to go over the debt relief, legislative, and licensing updates. So just to recap, our 2021-2022 state legislative and licensing update, which we went over in great detail at our annual workshop last month in Costa Mesa, California. I'm going to go briefly over the updates here for purposes of this webinar. Here you can see the legislative timelines, which show recent activity with bills being introduced among certain states. And next slide. So late last year in 2021, a bill in Ohio was referred to a Senate committee, which would cap certain fees and require debt adjusters to register with the AG's office. Turning to this year in 2022, in chronological order, we have seen activity among New York, California, New Jersey, and Massachusetts. Among other things, New York's bill would require debt relief companies to be licensed and would regulate the fees being charged to consumers. California's bill would require debt relief companies to register with the commissioner. New Jersey's bill would allow for-profit debt adjusters to conduct business in New Jersey with certain requirements. And Massachusetts bill would require debt management servicers to obtain a license and to allow consumers to cancel agreements without any penalties. This is just a very brief overview of these updates among the states. So for the FTC or Federal Trade Commission, we have seen an increased interest in cracking down on junk fees. These are fees like NSF, insufficient funds fees, which target consumers across multiple industries. On the CFPB side, Consumer Financial Protection Bureau side, we see that there have been approximately 84 enforcement actions filed. Not all of these actions have targeted debt relief companies, but it still shows a substantial amount of action taken by the CFPB to be an enforcement agency. And with the next slide. On the state side, for enforcement actions, we can see California. In California, the DFPI agency, which is the regulatory agency, cracked down on student loan debt relief companies, forcing them to pay millions of dollars in refunds and penalties for collecting illegal advance fees. In Minnesota, this was 2021, but still rather recent. The AG's office or the Attorney General's office entered into a settlement with a student loan debt relief company that also collected illegal fees from consumers. But they also made false promises, apparently, that the loans would be forgiven. And then in Wisconsin, the regulatory agency there issued guidance this year regarding unlicensed debt adjustment companies. And they've also gathered to specifically discuss the student loan debt relief space and potential scams. On the next slide. So we have 5 cases here brought under the TCPA, which are worthy of discussing. As part of this webinar. The first case, although it's from 2021, is very important. The Facebook versus, I'm going to probably botch this, but Do Good case, which held that a necessary feature of an auto dialer under the TCPA is the capacity to use random or sequential number generator to either store or produce the phone numbers to be called. This either or was a huge change to the law. The next case is the Kelly versus McClatchy Company. They held that the TCPA claims may be resolved by arbitration if it's required under a contract. The Panzarella versus Navient Solutions, they held that no violation of the TCPA where there was not randomly generated calls because the plaintiff provided contact information to the defendant voluntarily. So where there's voluntary, the voluntary providing of contact information, it wouldn't be a randomly generated call. And in the fourth case, the Hall v. Smosh.com, that case held that the party has no standing to bring suit under the TCPA where the party is not the actual recipient of the communication. And in the last case, the Mel v. Green case, uh, that court held that only random calls can trigger the TCPA, even if an auto dialer was allegedly used. So that's a substantial takeaway.
If I
And
could quickly jump
yeah,
in really quickly for the audience, I think it's
yeah,
also important that we've selected, but Jessica's done an outstanding job, is we've selected the cases for you following the Facebook versus Digrid from 2021. But there's still a lot of case law that's being developed in the TCPA area. And as you could see, just this year alone, between now, Third Circuit and a couple of California federal cases. I mean, this is really a subject matter that is still continuing to evolve.
right. And this is just a quick, brief overview of the recent litigation. There's a lot going on this year, but yep. So I was actually going to turn it back over to you, Felix.
Well, thank you. Yeah, and just a quick also note on TCPA. One of the things that you need to keep in mind if you're in-house counsel, chief compliance officer, or outside counsel for debt relief companies is aside from the TCPA judicial precedent still in the development stage, and we're likely to see more cases determining whether or not TCPA to what extent the auto dialer or the lack thereof applies on the federal level. If you attended the webinar or the in-person workshop that we had last month, we discussed states enacting their own TCPA type statutes. One particularly of importance is in the state of Florida. We about a year ago, our firm did a webinar specifically discussing TCPA litigation and legislative updates, and we did focus on the Florida TCPA law, which is a lot more narrowly construed than the federal law. And finally, there are other states, again, this is in all of our materials from the Costa Mesa workshop, that have enacted similar statutes, and we are likely to see the same. Overall, I imagine that we're going to continue to see TCPA lawsuits throughout the country in 2023. So that's sort of our first forecast. Now, thanks, Jessica. Thanks for this amazing presentation. The first part, let's turn over to the FCRA, Fair Credit Reporting Act litigation update. This slide that you see in front of you is what, again, we recycled from our last month in-person two-day workshop. But for those of you who haven't attended, this is kind of critical. There's a lot of activity in the Third, Sixth, and Seventh Circuits. The Third Circuit's of specific importance because earlier this year, as I will discuss in a few minutes, there was an important case stretching a very broad definition of what constitutes a consumer reporting agency. That case came as a surprise in February of this year. But the reason you have two buckets is for you to understand. The Sixth and Seventh Circuit has seen a significant rise in FCRA litigation, and we're working in a couple of cases right now where marketing companies' front ends getting sued, being brought in, and the allegations that they're acting as a consumer reporting agency, and there are cases even involving debt settlement companies and attorneys, which seems a little bit far-fetched for them because, as you know, the standards in the Sixth and Seventh Circuits are very different than the Third Circuit. I'm kind of curious to see whether eventually this will end up before the Supreme Court, if the Supreme Court would want to hear this case. But yes, the Sixth and Seventh Circuit are very, very active in FCRA litigation. So is the Third Circuit, and the Third Circuit is to be a watch out. And the Third Circuit is Delaware, New Jersey, and Pennsylvania. This is very, very important for you to understand that these three, if you're doing business in these states, if you're soliciting clients in these states, if you're licensed in these states, you need to be mindful that these are these three states, doing business in these three states could potentially create additional necessary headaches for you, right? Just to be aware, and we'll discuss in a second. I'll explain to you why. So the Third Circuit had two important cases this year. The first case, the Fugis case. I hope I'm pronouncing it right. Jessica and I always laugh. Sometimes we try not to butcher the names of the parties. But here, this was a case holding property report, not a consumer report, right? Where report did not include the plaintiff's social security number, payment history, previous addresses, employment information, date of birth, or outstanding account balances that would typically be in the consumer credit report prepared by credit reporting agency, right? So this is a case that actually is great. It has a very good interpretation that you can't just say that a proper report is a consumer report. It also gives you a little bit of an understanding that some plaintiffs try to stretch the definition of a consumer report, which is specifically outlined in federal law. And yeah, here the court did not agree. So you're saying, wait a second, why did you say a few minutes ago that the Third Circuit, those 3 states, are very important? And that's the McGrath case. Again, we discussed it at length a month ago in Costa Mesa, but let's talk about it again. And here the court found the court took a very strange interpretation of what considered to be a credit reporting agency, again, which is also defined at the federal level. And in this particular case, the defendants were looking at lien and mortgage information data filed with the courts, and somehow the court here determined that an entity is a credit reporting agency where an entity did not actually produce consumer reports. Again, let me repeat that, did not actually produce consumer reports, where an entity does not actually furnish consumer reports, but rather acts for the purpose of furnishing credit reports. And the term assembling on the FCRA only requires the gathering and grouping of information. So here, this company, the defendants were essentially, one of the defendants was assembling data filed with the local clerks of the liens and mortgage data, and for a very strange reason. And look, I mean, having practiced law for almost 20 years, I could tell you that from time to time you get a case that doesn't really make a lot of sense, and here the court really stretched the definition of a credit reporting agency. And you could be a credit reporting agency without furnishing credit reports. I mean, that seems very strange to me, bizarre, in fact. So yeah, the McGrath case is the one to be aware. And who does this impact in the debt relief industry? If you are a front end and you're ordering credit reports, let me say, if you are pulling credit reports, you need to be mindful, obviously, of the relevant laws and whether it falls into the permission. But also, if you're purchasing leads in these 3 states, and these leads may not even resemble any credit report, it doesn't fall within the 4 corners of credit report, but it could have some information that, for instance, or the assembly of that information that may be deemed to be a credit report, you could be you could be a credit reporting agency. So the McGrath case really, created a kind of a horrible wrinkle in those 3 states, and just wanted you to be aware of it. Anyway, moving on. 2 months ago, we had the Fifth Circuit Appellate Division in Texas. This is a federal court in Texas. This was a lawsuit filed by the Community Financial Services Association of America and Consumer Services Alliance of Texas against the CFPB. And essentially, the background of the case is that these trade associations who represent payday lenders and credit access businesses brought an action against the CFPB, alleging that the CFPB's payday lending rule, limiting a lender's ability to obtain loan repayments, violated the CFPB's authority and also the Administrative Procedure Act, and so on. Essentially, in a nutshell, the plaintiffs alleged that the payday lending rule wasn't appropriate, and also challenged other parts of the CFPB's, I guess you could say, statutory framework and the ways the CFPB was established. And this court created a lot of shockwaves, and I've seen different opinions from practitioners in this space providing feedback in this case. Some practitioners said this basically case is going to ruin the CFPB. The CFPB is going to get shut down, and because ultimately the court here found that while the CFPB was well within its statutory authority on the payday rule and its Administrative Procedure Act's payment provisions were nothing out of the ordinary, nothing that should really violate any type of statutory authority for the CFPB. At the very end of the case, the court issued its view that the bureau's self-funding structure, right, essentially how the CFPB and its employees and its efforts are funded, violated the U.S. Constitution's appropriations clause and the separation of powers. And ultimately, the holding said that the Bureau's unconstitutional self-funding scheme inflicted harm on the association and so warranted vacating the rule. So anyway, there's part of the legal practitioner community who will say this is a really bad case for the CFPB, and this is a black eye for the CFPB. And I've seen newsletters, I've seen announcements, I've seen continuing legal education courses that basically said the CFPB is doomed. Oh my God, the CFPB will be, like defund the CFPB, if you really wanted to use that word, defund the CFPB because it's not properly funded. I belong to the group of attorneys who believes this is nothing. I don't think this is a big deal unless the Supreme Court says otherwise. I do not see the CFPB is going to be dismantled. I don't think the CFPB is going to be defunded, and I think technically this could easily be fixed through just changing the way the CFPB will get funded from the U.S. Treasury. Yeah, I mean we've had the CFPB attend our workshop, and yeah, it's business as usual. To the contrary, I find that when people get too excited over a federal agency not having that constitutional authority, they're jumping the gun. But what they see is in the age of tribalism, right? And I think it's fair to say that the past decade or so, or the U.S. Society has been really split into these tribal groups, right? Republicans versus Democrats, liberals versus conservative. I don't think this does any justice if you're a marketplace practitioner, if you strongly believe that the federal agency is just going to be dismantled after being around for over a decade following the biggest financial crisis, I will respectfully disagree with you. We're on the verge of another financial crisis, and I think taking that approach is not going to get you anywhere. I think to the contrary, what I'll discuss in a few minutes, the CFPB is taking a more aggressive approach, and we're going to see a lot more activity. So for those of you who got all excited because you read some newsletters or some articles that the CFPB took a black eye, my position, and for those of you who are obviously repeat listeners of our webinars, I do not see that at all. I think it's business as usual, and I think it's going to get a little bit more than business as usual. But that's my view. So that, not afraid to express it. Yeah, so that's the key takeaway. I don't think anything is going to change. I think the CFPB is going to continue to exist. And to the contrary, it will continue to, I personally think it's going to continue to grow its jurisdictional powers. Okay. Now, which takes us to the next line item. But this happened 2 days ago. 2 days ago, you may have received a newsletter from our firm last night about this, and you probably have seen this in the press. This is pretty big. And I'm actually quite happy that we're doing this end of year webinar on December 14th and not before December 12th, just because this is pretty big, and do pay attention to this. So what happened 2 days ago is the CFPB issued a proposed rule. By the way, it's 200 plus pages. So it's not just like a little rule. It's over 200 pages, okay? That would require certain non-bank entities to register with the CFPB upon obtaining final orders and judgments issued by local, state, and federal consumer financial protection agencies or courts. So let's stay right here. What does that mean? What does that mean that they're going to require? So first of all, the first question is, what does it mean non-bank entities? And the proposed rules are silent. They're not just focusing what you think of non-bank lenders. No, no. This seems to be, at least my interpretation, and we had a for a meeting on this. We went through this very thoroughly. This could potentially affect every single non-bank entity which they have jurisdiction. For instance, debt relief companies, absolutely. Marketing companies, absolutely. Money transmission companies, crypto exchanges, absolutely. What does it mean to register with the CFPB obtaining final orders or judgments issued by local state governments or federal governments? That means there's going to probably be a repository, right? So what the CFPB is trying to say is we're going to create this repository, which is very, very similar to how the Securities and Exchange Commission or the Commodities Futures Trading Commission have it, where you could go in and you could see what regulatory actions have been taken against their member firms, right? Against their member firms. And what's actually more interesting is it's not just going to be member firms like you have. The SEC would only have the SEC or FINRA, a repository of FINRA or SEC-related enforcement actions or sanctions. Here, this would be everything. So, for instance, if you're doing business, if adopted in the current form, obviously these are proposed rules, but if you're doing business in the state of California and the California DFEI issued an order or their sanctions, this will be published with the CFPB. That's what they're trying to do, this goes back to what I said a few minutes ago. If you think the CFPB is just going to go away because the CFPB is this Fifth Circuit case to determine that its funding was in violation of the appropriation clause of the U.S. Constitution, well, I respectfully disagree. To the contrary, I feel like with this proposed rule, you just injected CFPB with steroids of additional jurisdictional powers and authority. So yeah, this is a very, very good example how things are moving in the other directions that a lot of other people thought. Anyway, the proposed rule specifies that all final public written orders and judgments, including consent, right? Stipulated orders and judgments obtained and issued by the CFPB, state, local, state, federal agencies must be reported to the CFPB registry. Now, let me give you from a practical example. We recently represented a company and had a settlement with the state of California. Can't go divulge any more information, but it was a settlement with an agency in the state of California. There's no repository for that type of settlement, so the settlement is not a matter of public knowledge, right? I mean, can you find it? Yes. I mean, can you try to find it through Google search? Possibly, if you really wanted to. Is there a repository in the state level of the state of California of this? No, there isn't, right? Now, imagine that now you would have to send that consent order that can't be easily found online to a federal registry with a CFPB. Well, that changes the ballgame because now if you're going to, it's going to come up really easily on Google. And obviously now people are going to go into the CFPB and if adopted in a current form and find this registry. So this is pretty big. What's interesting is that the proposed rules specifically carved out depository institutions, right? Like banks or credit unions. Why? Because those institutions are governed by other agencies. They're governed by the Office of the Control of the Currency, the FDIC. They're also governed on the state level with various banking regulators. And if you see the last bullet point here, the proposed rule also seeks to require certain non-banks subject to the CFPB's supervisory authority under Section 1024A of the CFPA, and which then begs the question, right? Which begs the question is, what does it really mean? Does that mean that if you are found in violation of CFPA, you immediately would have to go into the registry? It's unclear, right? So it's unclear from the proposed language if adopted in its current form, the rule may implicate non-depository for like debt relief provided. It's not clear, but you could say that, right? So, I want you to understand that while the extensive and substantive rules have been proposed 2 days ago, try to give a lot of focus on what the CFPB's ultimate effort is, which is create this, repository of sanctions, consent orders. Will the debt relief companies, right, be part of that repository? It's unclear. It's possible. It's definitely not out of the question. The proposed rules definitely did not say we will only intend to include these industries or these market participants. Nope, nope. It is pretty broad in its current form. So it's going to be very interesting to see how the CFPB in the final rules, whether there's going to be some kind of a line drawn, in terms of what entities would have to, what industries might fall into this. So again, this should be on your radar. This is ultimately one of the most important things that happened in 2022 from a federal perspective. Okay. About a year and a half ago, an enforcement action that was filed by the CFPB demonstrated that debt relief providers may also fall under Section 1024. It was stipulated this was a case against Burlington Financial Group that named it also named principals offering debt relief services. And in the CFPB, in the actual ultimate consent, it said they described Burlington as covered person under CFPB Section 1024A, and its complaint the CFPB alleged that Burlington offered to provide consumer financial products, including debt management, debt settlement, debt relief, and credit repair services. But anyway, how is this important? That shows to you that this, if to the extent that CFPA Section 1024 is going to be triggered, debt relief companies might potentially fall in the purview of submitting these if obviously adopted in the current form. Anyway, just also be mindful. If you remember the days of the CFPB director, Richard Cordray, right, who really had very progressive thought on regulating and overseeing the various consumer financial services companies, don't be surprised that, with the Democrats still holding the Senate and having a Democrat president and the Republicans having a very, very narrow, insignificant majority in the House, that we might see some pretty aggressive rules coming out in the next 2 years from the CFPB. So yeah, I mean, as you could see, our forecast, it's going to be very active. I don't necessarily believe, in my opinion, that the CFPB will necessarily focus on the debt relief space. I don't think there's any reason to believe that there should be, other than the student loan stuff. But focus will be fees and fees and fees, right? So junk fees, fees. It doesn't necessarily mean TSR. It doesn't necessarily, I want to stress this. I think this is one of the things that a lot of people are confused about. It's not only about TSR. You have to be mindful that when you charge consumer fees, right, there's a question of, do the consumers understand what these fees are for? Is it properly? Do they understand it from a layman's perspective? Is it disclosed? Is it clearly, conspicuously presented to consumers? So it's obviously very important to understand that the focus in our opinion is going to be on fees, fees, and fees. There's one thing to, and again, not necessarily TSR fees alone, okay? Because I think this industry has this sort of obsession with TSR, not necessarily in a bad way, but you are a financial services company, you are dealing with consumers. TSR is not the only federal statute that you should be mindful of, okay? Federal Trade Commission. So we haven't seen a lot of activity in 2022 with the Federal Trade Commission. Interestingly enough, the Federal Trade Commission has been, fairly active on the antitrust side, which is really the historical purpose, the significance of the Federal Trade Commission. That's really the reason why it was created in the first place. But about a month ago, we did see a case against the debt settlement company in North Carolina. They were seeking an injunction. I haven't really followed that closely what they find, if there's any further, adjudication against the company. That's why you don't want to mention it. But yes, they did file a case about a month ago. So it's interesting to see why it was the Federal Trade Commission and not the CFPB filing this case. I'm always kind of curious to see who makes the ultimate decision, who is to pull the trigger, which agency, right? Because a lot of times they are able to enforce the same type of federal laws or several, bucket of laws. But yes, we saw a recent case recently. Now, let me tell you my forecast for 2023. And I didn't make this prediction in the past few years that we've done this end of year webinar. I think we might see this year a criminal indictment, maybe more, from DOJ. I do. And you're asking, why do I think this case? Do I have any information? No, I'm not a criminal lawyer. We don't have any information, but obviously, we do this for a living. We represent many market participants, not necessarily only in this space. And the reason I decide this is my forecast is, well, it's that time again, right? It's that time again. If you remember, there have been a couple of, DOJ criminal investigations. DOJ obviously means U.S. Attorney's Office. One of the cases that caught, the eye of the public was the Mission Debt Settlement case, and that was about 10 years ago. So why now? And we are heading for a fairly significant recession. The consumers are hurting. Unsecured debt is up, and while that opens the room for good businesses to provide good service, that also opens up room for bad people, bad operators, bad apples to come in and and take advantage of consumers. And when that happens, typically that results in investigations. Now, next question is, why now? Typically in the years that are in recession or immediately following recession, you have these criminal charges filed. I also think that even though, you can't live in your bubble and think, well, if I'm a debt settlement service provider, or I'm a credit counseling company, or I'm a marketing company, a front end, right? Then, I am immune. No, you're not immune, right? Because what you're basically seeing is that consumers are getting torn apart in the crypto space, right? And as you probably know, as I said earlier, I do a lot of work in that space. It's a bloodbath, right? We have FTX on front page of the Wall Street Journal, New York Times, and in breaking news, and we have an arrest from Bahamas. I mean, I could tell you that it's not often that you'll see arrests in Bahamas and possibly going to get extradited to the U.S. That doesn't happen that often. You see other crypto exchanges. That means there will be billions and billions of dollars lost. That means that other crypto exchanges are going to fall. How does this relate to debt relief? Well, it doesn't directly relate to debt relief, but it indirectly relates to debt relief, because I think that once the regulators begin to sharpen their knives, they see who else we can go after. It's usually like a big tsunami wave. And that's my prediction, okay? That's my forecast, that we might see at least one criminal indictment in this case. Maybe I could be wrong, but that's my prediction. Anyway, AGs, state regulators, this is basically what I want to tell you. The state regulators have been extremely active this year. As I mentioned during the first part of this webinar, I think the first 7 months, I think through July or maybe early August, I mean, I could tell you that, I'm not just speaking for my firm, I could tell you that obviously we speak to many of other law firms who do work in this space. We could barely keep head above water. I mean, it was extremely, extremely active. It sort of slowed down in Q3, and it's on the quieter side in Q4. It's not as active. But the first 2 quarters of this year, I mean, across the board in the debt relief space, I've seen subpoenas, CIDs, requests for calls and meetings from regulators, state regulators, just almost on daily basis. It was overwhelming, and particularly the state of California was extremely, extremely aggressive. I was curious, how big is their enforcement department? I deal with many of the enforcement attorneys on a regular basis, but my goodness, it was difficult to keep up. But the states that were very active this year: Wisconsin, Ohio, Minnesota, Massachusetts, and California. We saw an enforcement action against a payment service provider in this space in the state of Massachusetts. They came out about a month ago, and that was a very unique action, because we haven't seen state regulators going after payment processors. It's really the feds. So I wonder if that's going to set a precedent. It's difficult to say, it's too early, but yes, those states have been very active. I know that people send me lists from other attorneys in this space. That's my list. These states were extremely, extremely active. I could tell you if I had said the one state that was super active this year, well, actually, I should say that kind of take the first place. It's California and Minnesota. Those two states, uber active, and interesting to see. I think that this is also going to be kind of carry over to 2023. DFPI, as I said, takes the front, takes the leadership role. They were very active. I foresee, particularly because their proposed rules to DFPI to regulate the debt settlement service providers. I foresee that this will be an active space. I do foresee the state of California being quite active. So, anyway, that's the end of my forecast with Jessica. Um, I'm very grateful for your time, for being to participate. As I always do, this is a list of the services our firm provides. Uh, you can always visit shipkovich.com for more information. I hope you subscribe to debtreliefwatch.com. It's free. You get to stay abreast of our news and information. And finally, thank you. Thank you very much for being loyal listeners, participating, and we wish you all the best in 2023.
Yeah, thank you, Felix, and thank you everyone for listening.
See you in the new year.